Well, the law can be a bit of a minefield sometimes, but luckily, Jess, help has arrived.
Triala Legal in Runaway Bay is renowned for providing top end of town legal expertise in all aspects of property law and guarantees all clients access to Despina Priala, the principal of the firm, who in fact has practiced property and commercial law for over 25 years on the Gold Coast. And thankfully, we're thrilled to have her here with us every Thursday to give some general advice on the latest hot topics. A very warm welcome to you, Despina.
Thank you, Jess. Good morning. Good morning, Wayne.
Yes, good morning, Despina. As usual, a couple of very, very interesting topics to cover. We'll have a look very shortly at social media. Now, because social media is constantly evolving, there's rules are changing from time to time. We're going to look at that. And well, it could actually have an impact on your on compensation. We'll look at that a little bit later on. But first up, we want to look at signing a contract. Now, of course, there are lots of traps for young players when it comes to signing a contract. But you've come up with perhaps 10 of the most common mistakes when it comes to signing a contract.
Well, I have, and a little bit more than 10.
Okay, I'm sure there's more than 10.
There's more than 10. So it's quite timely that I think I do this, because at this time of the year, everybody is signing contracts. I mean, we are absolutely swamped with work, and it's really good for the property market. So I thought it was quite timely to do this today, where we talk about the 10 most common mistakes made when entering into a contract, and then my list was more than 10. So naturally, so we can go through some of those this morning.
Actually, how many mistakes could there be? Would it be in the hundreds?
A multitude.
How long's a piece of string, Wayne?
Exactly, a multitude. So the very first big mistake is don't sign a contract unless you see a lawyer first. So that's the big one. And we tell clients that all the time. Don't sign a contract before you get some legal advice. Doesn't matter what the agent says, doesn't matter what anyone else says. Have your lawyer look at that contract. It won't take long. Nothing's going to, dramatically happen from the time you get your draft contract to when you get your lawyer to look at it, unless they're going to take days, which is unacceptable. So we look at the contract same day, pretty much straight away, and we ring the clients and we go through what is in that draft contract, and that's very important. So number one golden rule, don't sign a contract unless you get advice first.
And sometimes there's jargon in there that maybe we would not understand, so it's great that your eyes proofread it to know that there aren't clauses in there that really could affect your client.
Well, we understand contracts inside out, so we deal with them on a daily basis. So for us, or for me, it's easy, and for my staff, it's easy for us to just have a look at a contract and identify straight away, there's a bit of a mistake here, or is it supposed to be drafted in this way, or are you supposed to have something else included? So yeah, we can run through some of those this morning.
And where else are we going wrong?
So apart from not getting advice before you sign the contract, which is a big no-no, a common mistake is you've got the buyer's names wrong. Okay, so couples that might be buying a property, or family members or friends or whoever it is, if you've only got one buyer on the contract noted because for whatever reason, maybe the husband just wants it in his name or for loan purposes, and then halfway through the contract period, they want to change the buyer and they want to add someone. You can't just write on the contract another person's name. It doesn't work like that. So if you do that, you actually will incur a double stamp duty. So changing a buyer's name is a big issue, particularly in Queensland. So I say to clients, when I look at a contract, I say, right, well, the buyer's names are X. Is that right? Are these the people that are actually buying the property and that will go on title? Because once you sign it, you cannot change it.
Does that happen very often?
It does. It actually does. People don't think about it. They go, oh, well, if I have to change it, I'll just do it afterwards. No. Think about it carefully, about who should own this property and what names it should be being purchased in.
If you don't actually have the correct name, can that also cause a concern?
Yes, sometimes that you've missed a middle name or two middle names. That's not as much of a big deal as adding another buyer to the contract. That is the critical issue here. So often we have people who have different, like a passport and a driver's license have slightly different names, so we have to cater for that. Sometimes, depending on the actual difference, it can be painful or it cannot be. So,
for example, if you didn't spot it until you got towards the end of when everything is about to go through, suddenly you realise I've got the wrong name, or it's incorrect spelling, or not full name, etc. So it could cause a real issue.
It can, and it usually comes up with the bank. So the bank will look at what is the name on the contract. That's how they prepare the loan documents. It's all got to match. And when you go to your bank, you give your identification, like you give it to your lawyers, and that's when it gets all picked up and go, oh, hang on, these don't match. And then we have a problem. The real problem with that is not so much the duty issue when you're adding a middle name, but it's often the banks have to go back to square one and start all over again, the whole process of the finance approval and the issuing of loan documents, and that can put back your whole settlement. So it can actually, can become a big problem. Yeah.
Just when you thought you were sign, sealing and delivering.
That's right. So I say to buyers, look, if you're known by a different name, so if you have some identification in a maiden name, for example, it's another issue, and some identification in your married name, or you know that your passport and your driver's license don't match for middle names, tell us straight away. Usually we pick it up though, because we ask for identification and we ask the client, but sometimes there's other issues that they don't disclose. So important to get your names right above all. Another issue is inclusions. So a lot of people don't think about that. So they sign contracts and inclusions is part of the contract schedule. So if there are inclusions, you should list them because you're paying a price for a particular property, and sometimes often there are inclusions. There's always usually inclusions.
What sort of things are you talking about here?
So the basic things are, and people think they don't need to include them, but I say you do. Dishwashers, curtains, blinds, if there's a dryer or washing machine, not always. So those sorts of things. Pool equipment. So pool cleaning equipment, is that included? A creepy crawly, for example? Is there a shed at the back? Is that included? Any equipment in the shed? Lawnmower, things like that. Particularly on acreage property, there might be additional items. And sometimes you have negotiated furnishings. So if there's particular furnishings like a table, chair, a bed, anything else, write it in the inclusions, because if it's not in the inclusions, then it's deemed to be really not part of the sale.
Because you might walk through and think, oh, I own everything in this deal, but unless you specify.
That's right. And I actually say to clients, for waterfront properties, put the jetty and the pontoon as part of the inclusion. So whether or not it's technically or legally an inclusion, I always say write the pontoon and write the jetty in the inclusions. It's really, really important. And there's a reason for that, because we had an example in the last few weeks of a client who didn't write that in when they signed a contract. And we had to make inquiries whether the pontoon was actually approved, which is another common mistake. And when we actually discovered that there was a pontoon, it wasn't in the contract, we asked for it to be included. So the contract was varied to include the pontoon. Then we embarked on inquiries about the pontoon, and we found out the pontoon was never approved at all. But this particular property, what happened was they actually ended up terminating based on our advice, because the pontoon was never approved. And further inquiries led the buyer to find out that, this particular pontoon would have to be removed because it was never approved.
So there's
And
another
that could have been
cost.
costly.
Another cost.
Yep.
And then the big clincher was this, that they wanted to then put another pontoon to be approved, and that particular property, the council won't allow any pontoons anymore under new regulations.
So how is that house going to sell?
Exactly. It's a very odd house, a shaped house as well, because the waterfront area was down a sort of a laneway. It wasn't a normal house right facing the water. So it was very narrow, sort of entrance to the water front area. And so they discovered they could never ever have a pontoon, so they terminated.
Well,
Validly.
they went to you.
Yes, exactly. So that's a common mistake. Other ones, wrong timing for finance, pest and building conditions, or not even having those conditions at all in the contract. So most people need to get finance, have it subject to finance always, and have a reasonable period. This time of the year, very hard to get finance approved in 2 weeks.
Yep.
So we normally say 21 days for a finance period, for example. Pest and building report, you usually have 7 days from contract date to get that done. At this time of the year, it might be hard to find an inspector to actually carry out that within 7 days and get a report done, so you might want to extend that period. Another big common mistake, just on conditions and timing, is settlement. Settlement date is can be a big problem. So we often find people go, oh, I just want a 30-day contract and it'll all be over and done within 30 days. Well, if you actually say your settlement date is 30 days from contract date, then you are stuck with that calculation of that date. So you calculate it from the beginning, what is 30 days, and you come up with a date everyone agrees to. But what happens if your finance has to be extended? So say you couldn't get your finance in 2 weeks and you had to extend that and it was extended for another week. You still have to settle 30 days from contract date.
Yep.
That's a massive problem. People don't understand the timing. So we often say the settlement date should be 14 days from finance approval, for example, or 21 days from finance approval. So that is a big common mistake. So always look at the conditions and the due dates and how it's all going to work practically.
So you actually have money to pay for it.
Yeah, exactly right. And another one is swimming pools. So do you have a swimming pool? This is a big common mistake. If you have a swimming pool, as a seller, you're supposed to provide a pool safety compliance certificate or disclose that you don't have one. And either ones can have consequences. So if you have a pool safety certificate and you don't attach it to the contract, might be a problem because you're supposed to. If you actually don't have the pool safety certificate compliance at all, then are you going to get one? Or you're going to leave it to the buyer, and if you leave it to the buyer, it's got to be written in the contract that
they have to factor it in.
Responsibility and acknowledge that there is no pool safety compliance certificate. So it's one of those common mistakes that people don't cover off properly.
Well, there are plenty of mistakes for the unwary. I think your first suggestion was to go and get legal advice. I think that's probably the best one that covers all of them then, doesn't it?
From someone who is experienced in
yes.
property and contracts.
That's
yes.
it. That's
Which
it.
you certainly are.
This is Radio 97. It's Talking Law. Despina Prialo from Prialo Legal is available to answer your questions. If you have a legal question, whatever it might be, just send the details to breakfast@radio97.com.au and we will ask your question on your behalf. Coming up after the break, we'll talk about social media, talking about there's all sorts of, what are we calling it? There's all sorts of issues around social media. We'll look at a couple of those in just a second.